Policy Governance Committee of the Social Equity Council. For those who are joining us for this committee meeting, good morning and welcome. I am now calling the meeting to order. And our first order of business is for me to take attendance. So we have Avery Gaddis, Councilman Gaddis.
Here.
Councilman Ojala Naeem. Councilman Michael Jefferson. Councilman Shirley Skyers Thomas.
Present.
And I am the chair, Ed Shirley. We have a quorum. The next order of business is approval of the September minutes. Let me take a moment to review, and I'll take a motion whenever you're done.
Through you, Mr. Chairman, I move acceptance of the September meeting minutes as submitted, Mr. Chairman.
Thank you, Councilman Gaddis. May I second that, or do we need
someone else need to second it?
Okay.
I'll second that.
Thank you, Councilwoman Skyer Thomas. Been properly moved and second the September minutes for acceptance. Those in favor, please indicate by saying aye. Aye.
Aye.
Any opposed? The minutes are approved. The next order of business is the review and vote on the new criteria and guidance for social equity applicants. Attorney Matravy.
Thank you so much, Chairperson Shirley. So as we regularly do every year, we review the criteria for update, especially when the legislation has been amended. This year, we did the same thing and proposed a few updates to the criteria. In addition to this update, SEC staff has proposed guidance on these criteria by providing a definition section to the criteria document, which shows how certain terms will be interpreted by SEC to provide more information to the social equity applicant. The most important of those terms is commercially reasonable transactions, what it means, and what does not qualify as commercially reasonable transactions. We provided a list, a non-exhaustive list of what does not qualify as commercially reasonable transactions. The criteria itself, per the changes in the legislations, Councilmember Naeem is joining.
Thank you. Welcome, Councilman Naeem.
So for the criteria itself, there's been a couple of changes in the statute. Previously, the threshold for ownership has been 65%, but the threshold of control also was interpreted to be 65%. However, the legislature changed the level of control to simply require a simple majority control, which is anything more than 50%. And that goes for all applications that SEC will receive. Even equity joint ventures will have to meet the minimum level of control, which is anything over 50%. We did include in this ownership and control criteria a standard for agreements between social equity individuals and backers. Some of these requirements are about arm's length transaction. The negotiation should be an arm's length transaction, meaning each party should have their own legal counsel reviewing this document and providing them with independent legal advice. That way, individuals are not influenced by the other person's lawyer. There's also a requirement that the transaction meet the commercially reasonable transaction standard, which has been created in this criteria. In addition to that, we include a requirement for third-party agreements and management services agreement. These third-party agreement, management service agreement also have to meet the arm's length transactions requirement. In addition to that, Councilmember Jefferson is joining.
Oh, thank you. Welcome, Councilman Jefferson.
Good morning, Councilman.
Good morning.
In addition to the arm's length transaction requirement, which, as I said, show a certain fairness in the negotiations, we also include a requirement that the party include clauses in the agreement, such as alternative dispute resolution clauses, so that Social Security applicants who usually don't have a lot of financial resources are not facing intensive court battles right away. So all those changes have been included in this new criteria that we propose SEC to adopt. Now, when it comes to residency criteria, before I go to residency, the criteria also include the documentation. As you know, per the statute, the council has to provide a list of documentation that's required for folks to meet every criteria. The list of documentation hasn't really changed. It's been the same list because it's worked in the past. So we haven't removed anything really from this list. Now, when it comes to residency criteria, the legislation has not changed with regard to the requirement to live in the DIA not less than 5 of the 10 years immediately before applying for the license, or not less than 9 full years prior to attaining the age of 18. What we did in this regard is that we included certain guidance about some of the documents, such as birth certificate, proof of identity, and especially about affidavits. Per this guidance right here, Social Security individual may submit affidavit from persons other than themselves to support their residency claim. The council reserves the discretion to weigh the credibility of an affidavit based on an indicia of reliability, such as supporting documentation submitted with the affidavit. So that will allow the council to deny applications that have a self-serving affidavit if there are no other concurring evidence in the file. Finally, when it comes to income criteria, the statute didn't change with regard to income criteria. There's been an update in the state median income. According to the American Public Survey, the state median income for Connecticut in 2023 is $88,429 per household. So during the application cycle 2023-2024, which will start after this criteria goes into effect, this is the amount that we will be looking at. And since the statute requires 300% of the average state median household income to be less than, require the income of the household to be less than 300% of the average state median household income, that number will be $265,287. And for the purpose of the review of the income criteria, SEC only consider the adjusted gross income as shown on tax document submitted by the individual members of the household. And the documentation required to approve these income criteria documents are also pretty much the same and did not change substantially. So if you have any questions, I'm available to answer.
Thank you, Attorney Matravy. Appreciate that overview. Are there any questions for Attorney Matravy? Yeah, Councilman Jefferson, your hand is up.
Thank you. Through you, Mr. Chair. Thank you. Attorney Matravy, so these changes, give us an idea as to what sparked the initiative to make the changes as presented by you.
Thank you so much, Councilmember Jefferson. Through you, Mr. Chair. These changes are based on our assessment, based on 1 year of a full review of these applications. The third-party reviewer made recommendations that we should include in the criteria to make the criteria more transparent for the applicant. That's why we went to great length to provide even a definition section for the members of the public to understand how we understand how we interpreting some of these terms that we use to review the criteria. And also, as you are aware, the statute has changed with regard to ownership and control, and that also play a role in changing the criteria. Now, reviewing this ownership and control document for over a year, the third-party reviewer has documented issues that came up in some of this review with regard to third-party agreement and with regard to management services agreement, mostly. So it was important for SEC, for us to recommend that SEC also addresses those issues by providing clear guidance to the industry. That way, they have enough time to update their document before the next round of lottery.
So these will go into effect for the next round. Are we in any way, will we have to revisit any decision we've made based on the changes you're recommending?
We don't have to revisit any decision that we've already made. So these criteria will not become effective until February. And will apply to whatever application we receive from that moment going forward. So anything that we've already reviewed and approved have already been approved, and that's it for that. So
I'm worried about the ones that have been declined. Can they come back and say, because of the changes, we wish to be reconsidered based on the new language and the new criteria? Is that a possibility? I know people could sue for anything, but I'm just asking, should we expect?
Okay, so those who have been denied by the Social Equity Council under the Uniform Administrative Procedure Act, they have 30 days to file an appeal. And if they have not filed an appeal, they cannot come back and ask the council to apply this new standard for them. So that's not gonna happen. I don't see how that will happen.
Great. Thank you.
Thank you so much, Councilmember Jefferson.
But I see Director Clay, you have your hand up.
So I just want to clarify that if we denied a claim of an applicant before, can the applicant make a fresh, brand new application?
Thank you for that question, Director Clay. So equity joint ventures can renew their application. An equity joint venture that has been denied can resubmit, can amend the application and resubmit it. However, we treat every resubmission as a new application, not a continuation of the old application, because when they resubmit the application at the Department of Consumer Protection, the application will receive a totally new position in the queue with a new application number and everything. So whatever criteria is effective when the new application is submitted, that's the criteria that's applicable to the applications as it is submitted. So if we deny someone in December, an equity joint venture in December, and they wait to resubmit the application in March, the criteria will become effective in February. So the new application that they submit in March will be governed by these criteria that you all are reviewing today.
And will they have to, they'd have to
Okay,
start the process from there? From that, is it a new application or it's a review? We're submitting it now from, from before. It was denied once. Now we're going to resubmit in March. Is it that we're reviewing the same application but differently?
It's a new application that they're submitting. They have to fill out the whole thing
The
all
whole
over
thing,
again.
okay.
It's a new
All right.
application. They may even decide to change their proposed social equity individual or backer. Like it's considered totally new application.
And just one, again, just to clarify, those who participated in the lottery that were denied, can now reapply. There is no preclusion from them applying all over again.
Those who applied for the lottery last year got picked and then denied. When the new lottery is opened by the Department of Consumer Protection, they may try their luck again and apply for the lottery. And if they have been selected again, they will submit their new application will be reviewed based on these new criteria, because these criteria will be in effect then.
Thank you.
At the current time, though, we do have certain, I guess, certain applications are being reconsidered now for appeal. And if so, how does that does the new, requirements apply to them at this point?
Thank you so much for that question, Chairman Shirley. So for the applications that are currently going through the administrative appeals process, those applications will be determined by the judge. If the court decides to remand those applications back to SEC, then SEC will review those applications based on the rules that were applicable to those applications at the time the decision was taken on them. So if, for instance, right now the court has remanded an application called Red Barn Farm, because at the time they previously submitted the application, they didn't attach any document at all. And our criteria said if available. So, and because of that, the court allowed them to come back, reapply, resubmit the document for the council to review. So the council will have to review those documents and determine whether the person qualifies or not.
On their existing merits, I guess.
On the existing merits, yeah.
Merits.
Yes. Yeah, because it's like the file was never closed, really.
Okay, file is still open. Got it.
It's still open, yeah.
Understood. Are there any other questions for Attorney Matravy? If not, I will take a motion to accept the new requirements as presented for presentation to the full council at our next council meeting.
So move.
Second.
All right, all those in favor, please indicate by saying aye.
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 Are there any opposed or abstentions? All right, then it has the new documents, new requirements have been approved, and we will present them to the council at our next council meeting, which is November 8th, I believe. Is that
That's correct.
Okay. Thank you. Is there any other new business?
You, Mr. Chair, I like the backdrop there, Attorney Matravy and Madam Executive Director.
This is what happens when you get new staff. One of our new folks, Vera, designed this for us, so we're all set. You guys are more than welcome to it as well. We will send it to you if you'd like to use it during council meetings or committee meetings.
Is
I'm gonna
that
stick to my purple and gold. Go.
I hear you.
what's that? Is that a portal to heaven? Or purgatory? I mean, which is it? I don't know. All right.
Mr. Chairman, if there's no further business, I move to adjourn.
Thank you.
I second the motion.
Thank you, Councilman Gaddis. It's been probably moved and seconded. Do we need to vote? I think no, we'll just adjourn. Thank you very much. Thank you, everybody.
Thank you, guys. Have a good weekend.
Take care. Have a good one.